And good afternoon, everybody. This is Law 2020, brought to you by the BCN Law Firm. That's right, BCN Law Firm, offices Winter Park, Claremont, Lakeland, and the Villages. That's right. During the week, you can always contact the law firm at 855-LAW-2020. 855-LAW-2020. Videos of this program can be seen on the BCN Law channel on YouTube. You will see the host from the BCN Law Firm. You will not see the radio host. Wow, that's kind of neat. It's kind of like watching Home Improvement and the neighbor. Never see his face, right? That's okay. Hey, enjoy that. You'll enjoy the content. We are very blessed and very happy to have with us today a new guest from BCN. It is Eileen Mazinets, kind of like Raisinets, but Mazinets. She is a litigator. So we're taking your legal calls right now. If it's something that we can answer right now on the air, we will do so. If not, you'll get a follow-up call from the law firm this week. And we want you to join the show right now at 855-297-9696, 855-297-9696. Text us at 21232. That's 21232. Or use the all-new open mic feature of your News 96.5 app on your smartphone. You simply open up the app. You'll see a series of blue buttons. One of the buttons says open mic. Touch that. You'll see a little red button appear. You press that, and you are recording, and you're coming right to us when you press send. That is a cool app, and that way you can just set your phone down and go on about your business while Eileen answers your question. Hi, Eileen. How are you today?
Hi, Don. I'm good. How are you?
How long have you been around Orlando?
I have been in Florida for a total of 4 years in July. Before that, I was living and practicing law in California.
Wow.
Yeah.
So welcome to the Sunshine State from the state of fruits and nuts. Come out here.
Thank you very much. Thank you.
That is great. So what about the BCN Law Firm attracted you to that very, very resourceful group?
Well, first of all, they're very nice people to work for and a good group of lawyers. They have they care about their clients. And what I really liked about them is it's a full service law firm. They got everything from litigation, probate, foreclosures, family law. So there's just a lot of things, and I felt like it would be a good fit for me.
Great. And it's worked out very well.
Absolutely.
Very good. And your husband is also here in Central Florida, and what does he do?
My husband is Josh. He works for a company called Intuitive Surgical. He is a training specialist. He trains physicians on how to use that Da Vinci surgical robot out of Florida Hospital. Very
cool. Yeah. So cutting-edge technology runs in the family. All right, the BCN Law Firm, the show is called Law 2020. Now, to begin our conversation, there's probably a lot of people who say, all right, Attorney Wade Boyette comes on, Attorney Heath Nalos comes on, Attorney Brian Monk comes on, and now we're talking to Eileen, and this is a person who's entitled a litigator. There's probably a lot of people in our listening audience who have no idea what a litigator does or what the term even refers to, except maybe they've heard the word litigation.
Yes, well, a litigator is someone who obviously either brings a lawsuit or defends a lawsuit on behalf of a client, whether a plaintiff or defendant. So we call a case getting into litigation once you actually file a lawsuit. So once you file a lawsuit, you're in litigation. And so what I do is represent either individuals, corporations. I either bring a suit on their behalf or I defend a suit on their behalf.
Would you be the person that would make the decision about to the merit of a case? Because as we know, part of being a great U.S. citizen is we can sue anybody for anything. But maybe we're suing them in a way that it's just the court would laugh it off, or there's really nothing there, doesn't have merit. Would you balance that? Are you the person that does that?
Absolutely. I don't like to take a case unless I feel there's a real legitimate basis to bring a lawsuit. If I believe that there's not a good claim, I'll let the client know. There's no use in wasting anybody's money or anybody's time if there's nothing there. Same with if I don't think they have a valid defense or they think they have a great defense, I'll I give them my recommendations and I give them my opinions, but it's ultimately their call as to what they want to do.
Okay, very good. And did you see a great difference in state law between lawsuits in California and lawsuits in Florida?
There are There's differences as far as the procedure. Florida's got its own rules of procedure. California has different rules of procedure. So for me, that's been a little bit the biggest challenge. But
Yeah.
litigation is litigation anywhere you go. The same types of claims, but defenses are different. But just the rules of court are a little different. But that's about it. Not a whole lot of change.
And it seems to me that you'd have to be on the cutting edge of about everything that's going on and have a working knowledge of an awful lot of things, because there seems to be waves. There seems to be times where all the lawsuits seem to have to do with malpractice, or all the lawsuits have to do with an automobile defect. They seem to run in waves, I guess.
I
As
agree.
news people, we see that.
Yeah, I agree. I mean, when I moved to Florida, the first thing I got put on my desk was sinkhole litigation. We don't have sinkholes in California. I was used to earthquakes, so having 150 cases and litigation for sinkholes was a different animal. But you learn as you go.
Yeah, and going to sue Mother Nature? Well, but there's other people. Hey, let me ask you this: when we were talking in our pre-meeting, you were discussing the fact that there's retainer or there's hourly. And we have a question from Mike, who kind of is going to get us started on that conversation.
Okay.
So, Mike, we're going to ask you to join the show right now. Thank you for calling in, and tell us what your question is for Eileen.
I'm just wondering what a person should expect to have to come up with for a retainer for adequate counsel.
Hi, Mike. Yeah, that's a good question. It really depends on the type of case and the complexity of the case. Do you have a specific a question as to what type of case it is?
Well, it's part of a bank litigation. I'm not a part of a class action lawsuit, so I get to possibly get an arbitration, or in fact have to sue over an issue with one of the major banks. And I spoke with someone else about it, and they said, well, you may have to pry open Grant's tomb and cough up the money for a lawyer, and I have no idea what to expect in the way of what cost would be for retainer.
On a class action lawsuit?
No, it's not. I'm not a part of the class action.
Okay.
It could be sued on part of the individual.
Oh, okay, understood. Really, it just depends on the complexity of the case and the attorney you retain. As far as the attorney you retain, if the attorney is an experienced attorney, 5 to 10 years or more, your retainer is going to be bigger. But something, at least for me personally, if it's a simple case, not super complex, but it's going to be in litigation, and I know it's going to be in litigation, I'll probably charge anywhere between $1,000 to $3,000 for a retainer.
Okay.
Yes, go ahead.
Now, seeing that this has been through class action status, and I know that I don't know how it would go without a damage suit respective to recouping the legal fees, as part of the litigation. I don't understand that part about if I take them into court. I think I understand your question, and if I don't, just correct me. You're going to be paying an initial retainer amount to have an attorney represent you. What happens is that as that attorney does work on your file, then your retainer is going to be reduced probably every month pursuant to the work that's being performed. At the end of the litigation, you're probably talking about attorney's fees to the party that prevails in the lawsuit. What that means is that if you end up winning, or whoever ends up winning gets their attorney's fees paid for, it's still going to require a request of the court at the end of the conclusion of the litigation. But if you're the prevailing party and that's what a statute or a contract allows for you, then you would be entitled to those attorney's fees back.
Okay, that is a great conversation. Now, that leads us to a continuance of the conversation we had in the conference room a few minutes ago, otherwise known here as the kitchen. And that was, you were talking about that if people are billing by the hour versus billing on a retainer, you kind of handle things differently because you're very client friendly.
Right. I don't like my clients. I do work both on contingency and on I do hourly work. Contingency means I'm going to get, or the firm's going to get, a percentage of whatever settlement amount comes along in favor of the client. On a billable case. Mm-hmm. On a billable case, what happens is that I'm charging my hourly rate, and whenever I do work on a file, if I write a letter or I answer emails or I prepare a pleading for the court, I'm going to be charging that file per hour. Sometimes clients get a little surprised because at the end of the month, they're going to get my bill. And if a client, for example, calls me 10 times in one day, I'm going to be billing for each phone call. So what I was telling Dawn is that the best thing to do so you don't faint when you get my bill is you make sure you leave all your questions for the end of the day, as opposed to, calling 10 times, because each time any attorney is interrupted from doing something else and to work on a file, which is great. You're going to see that at the end of the month. So best thing to do, leave your questions for the end of the day, the end of the week, do it all in one email. That's my suggestion, because I've had clients that are not very happy when they see that.
I like that. Very, very good. So this isn't a social visit, folks. You're not going to be calling her 12 times a day unless you want to pay. Hey, we're going to come back with Rick and with Martha and any texts that we might have at 21232. Again, for the sake of explanation, a lot of people don't understand it. They say, when Rob says 21232, what is he talking about? Well, if you get out your smartphone and go to the messaging app on it, you're going to see on your messaging app, it's going to say recipient or contact name or address or whatever. Right there in that little one line, you just put the numbers 21232. That is our contact number. It's not a phone number. It's a computer code for a company called Mogreet. Okay? And then you're in like Flint. Your question will go right on our computer screen up here, and we will read it as Eileen goes through the show. So that's what we're going to do. All right, Rob Newton with you until 1 o'clock today. Then we continue to ask the experts all weekend long right here on News 96.5. We are 5 minutes away from news, traffic, and weather with veteran newsman Dave Wall. We have a full staff in the newsroom right now covering Orlando and all of Central Florida. And, of course, our partners with ABC and CNN watching the world. So you'll get news 24 hours a day. And if anything breaks, you'll hear it first right here on News 96.5. Don't forget, tomorrow morning, first thing, you turn on that radio bright and early, 5 o'clock. It's Central Florida's only all-news morning show with our good friend Joe Kelly. How does he wake up at 2 o'clock in the morning and do that nonsense? I couldn't do that. Anyway, it's a full crew in the morning. There's like a whole team of people. News 96.5, you want to talk to Eileen right now from the BCN Law Firm. It's 855-297-9696. You could text us at 21232. No text right now. 21232 is the number. Let's go back to litigators. Does this also come to major cases? Like, have you sued like some of the big companies in our country?
In the country, we sue a lot of insurance companies. Our firm does a lot of first party litigation. So if there's issues with, like I said, we also do sinkhole litigation. So if there's issues with your insurance company not wanting to pay benefits for sinkhole damage to your house, we'll sue major insurance companies for those damages. So it can be from your ordinary average Joe to a corporation. It doesn't really matter. We will do it.
Do you find that some people walk away too early? They just think, well, I'm not going to take on, like the previous caller wants to take on major big mega bank. Do you ever find like people, even with the sinkhole, they don't want to take on State Farm or Allstate or anything, and they just go, well, I don't know, Eileen, I probably should have called you, but I thought there's me, and then there's that big law firm, and, there's big insurance company with all their lawyers.
Right.
Do you ever just think that people give up too easy because they think companies are too big?
Well, what I like to tell clients is that once you retain us or our firm or me specifically, we do all the work. So I'm holding your hand. I want you to make the best decisions for you, and I want you to know that I'm going to be handling it. So once you retain a litigator or an attorney, they're going to be the ones that are dealing with the insurance companies or whatever corporation you're referring to. So you don't have to. So we take care of all the dirty work. We'll just call you when we have settlement offers on the table, when there's something that needs your attention.
That is the best thing possible. I know, in any legal matter I've ever done, I always in the past had a tendency to try to be in control. I'm sure you got clients like that.
Absolutely.
Calling all the time, saying, hey, have you thought of this? Have you thought of this? Have you thought of that?
Yeah.
It's better just to leave it alone, right?
Yeah. But if you have questions, obviously feel free to call me. and let me know what I can do for you. But we're working your case every day. Or if there's, we're dealing with opposing counsel, we're dealing with the courts on your file. So some people get a little antsy when their case is in litigation, and I understand that. But it's my job to be a good communicator with you and keep you apprised of what's going on. If there's any significant developments, no, you're not going to be kept out of the loop.
Cool. Let me ask you this. We are a society that solves on television an entire lifetime of problems in 30 minutes, which is actually 22 minutes after the commercials. In an hour, we solve a case for NCIS of world proportion. I'm sure you get clients who say, how long does a lawsuit take to settle?
Right. That there's a myriad of scenarios. I have clients that they file a lawsuit, one day, and then the next week they think that the case is going to settle. It doesn't happen that way. There's a lot of facets in litigation. There's depositions that are going to be taken. There's subpoenas that are going to be issued. There's written discovery, which is questions that the other side is asking you. So it depends on the case. It depends on how many cases that particular judge who has your case has on his docket. I know, for example, in one of the counties in litigation that we're dealing with, one judge has 6,000 cases on his docket. So that client isn't going to get to trial probably before 3 years. So I would say no less than a year for a case to actually get before a jury. That's different than litigation. Once you file a lawsuit, you're in litigation, but for your case actually to get heard by a jury, probably no less than a year.
So when do you make the determination, or does it vary by case, of telling your client you'd be better off for us to take this settlement offer and just call it a day?
Settlement's always a good thing.
Go ahead.
Settlement's always a really good thing. If there's something that we discover about our client, or there's something we discover about the opposing side, that might be the time to get that case into settlement discussions. But we're trying to get the case settled almost from the get-go. But every side has to go through a process of discovery. I need to get documents from the other side as to what the claims are or defenses are of that person. And the same with our client. People want to know what our client is claiming or what their defenses are. So it depends on what we find, but we try to get these cases settled in mediation mostly. And mediation is a very, very good way to try to get these cases settled. It's an informal process outside of the actual judge on your file who tries to get a case resolved.
All right, very good. All right, we're down to just a few seconds left in this segment. It flies by, folks. No doubt about that. Join the conversation at 855-297-9696. Hey, without using your real name, you could call Eileen and just say, this is what happened to me. Do I have a suit? Or I've been summoned or given papers. What do I do now? What's my defense? All right. And how does the social media enter into all this? Can things you put on Facebook be used against you if you're in a lawsuit? Eileen's over there. She can't wait to tackle that one. We'll be back on News 96.5. Hey, the name of the show is Law 2020. We're asking the experts all weekend long right here on News 96.5. We got great shows coming up all through the rest of the day, so we hope that you will stay tuned. Now, this show is called Law 2020, and it's brought to you by the good folks at the BCN Law Firm. You talk about people that are community-oriented, they're involved in their community, but they're also staffed with people that help you, care about you, keep you informed on your case. They know Florida like the back of their hand. Wade Boyette, Heath Nalos, Brian Monk have been our guests. Now we add to the lineup, and I'm glad we did, Eileen Mazenetz, right? Did I pronounce that right?
Right,
Pretty
Rob.
close?
That's right.
Move that microphone down just a little bit there, Eileen. Thank you so much. And Eileen is a litigator, if you're joining us a little bit late. And we're going to go over what a litigator does here in a minute again, in case you're just joining the conversation. But we invite you, if you have any legal situations in your life and you need a few minutes with an attorney, the folks at BCN are always more than happy to talk to you, and they talk to you as a friend. 352-394-2103, or the simplest way to remember is sing that song to yourself that you hear on the radio all week, 855-LAW-2020. Eileen, do you sing that? Do you sing
No.
Okay, we'll have Tim sing it. He's our producer. 855-LAW-2020. Go to the BCNlawfirm.com, BCN lawfirm.com, and you can watch this show. You can actually see Eileen next week once this video gets put on YouTube on the BCN Law channel. You'll also hear my voice off in the distance somewhere, and that's because of a contract obligation I have with another company outside of Orlando. Okay, now we have some text coming in, and this is kind of a fun one. Is alimony automatic at 10 years of marriage? I happen to know that at 20 years, it certainly is, but I don't know anything about 10 years. What do you know?
Yeah. Questions dealing with alimony are probably best left for an attorney that does family law. And Rob can get you the number, and the person to speak to at our firm would be Brian Monk.
Brian Monk, there you go. 855-LAW-2020 is the phone number. 855-LAW-2020. This is also a question of family nature. Is inheritance part of a divorce settlement? I guess in a lawsuit, anything you put in there is part of it, right?
Yeah, absolutely. But again, that's also a family law issue, and I would direct whatever call or whatever person that texted to Brian Monk as well for those issues.
Do you find, and I'm sure you do, but do you find in a lawsuit as a litigator that there's a lot of negotiations, like maybe you'll agree on paragraph A, B, and D, but not C, and that affects the outcome of the lawsuit?
When you draft a settlement agreement with the other side, you can be as creative as you want. You can put things like, I'll give you $5,000 and you give me your cat. I mean, you can be as creative as you want. Whatever gets the job done, whatever makes your client happy, whatever makes the other side happy. But probably one of the longest parts of when you finish a case is drafting that settlement agreement, because things will come back to bite a client at the end. So you want to make sure you've got the right language, the right phrases, the right everything, the right recourses if something doesn't get followed in that agreement. So parties can settle with whatever, I mean, at the end.
Have you ever had it arise in your law career that someone has, they've settled, not in court, but they've just had an out-of-court settlement, mediation or whatever, and they're supposed to get $50,000 in 60 days? And the person calls you and says, Eileen, I didn't get the money.
Happens a lot. You make sure that settlement agreement is very tightly written. And usually if something isn't complied with, you get on the phone with the other side's attorney and you find out what's going on. If there's no explanation for it and you can't work it out, there are provisions in a settlement agreement that say, well, if you guys have breached the settlement agreement, then this can be a new breach of contract claim. And now you file another breach of contract claim in that court for that breach.
Mm-hmm. And do you find ever that a person that is the subject of a lawsuit tries to get fancy and tricky and try to do something like claim bankruptcy automatically or sell the said asset that may have been part of this case? And is there action that can be taken in court that says, hey, all they're trying to do is cover themselves?
You got to make sure that the person you're dealing with on the other end is legitimate. So if you've been going through litigation with another side, you pretty much know their financial background, and that's why you agree to a certain settlement number, because you know that they can do it. So hiding money, does it happen often? It can happen sometimes, but again, a type-proof settlement agreement is going to get you a long way.
You have got the most interesting job, I think, of anybody I've talked to. This is so cool. A litigator. How neat is that? Okay, let's go, because you lit up like a fireworks display when I said social media. All right. We have been barraged. In our lifetime, we have seen this become a big part of people's lives. 10 years ago, nobody cared. There was, you weren't on Facebook every hour of the day checking it. You weren't on Twitter. Now there's major corporations, and including the Pope himself, who makes declarations on Twitter,
right,
for crying out loud.
Right.
The president does. So, all right, I've been in an accident, and I've been injured, and I'm going to be party to a lawsuit.
Correct. Okay.
What do I do? Do I close my Facebook account? Do I go on there and say, no, I had a great day, went water skiing yesterday and only fell twice? I mean, where are the borders here?
I guess if you're a party to a lawsuit, personally, I would close it during the pendency of your case, because if you get in a lawsuit and you're injured, you don't want your neighbor taking a picture of you mowing your lawn or having a party jumping on a trampoline. That doesn't go well if you're actually claiming money for damages. And you don't want a friend to accidentally post, well, so good to see you at the races, when you say you can't walk anymore. So I would temporarily close it till the end of the litigation is done, because anything that you put there or someone puts for you can certainly be used not in your favor in litigation. So I've seen Facebook pictures come to my client's face when they're being deposed by the other side, when someone's claiming an injury. You don't want that to be used against you. So be very, very careful with what you post.
There are even people who say to me, and I don't know it to be true, but I don't know it to be false, that in some cases, if you're a party to a lawsuit, the other side may very well have people who legally are following you or observing you to see just what you do.
Absolutely. They can do that. They can do that. So just be careful.
So don't be picking up any TVs or boxes or, working construction if you say, yeah, I have a hard time using my hands now.
That's what we call impeachment evidence. You don't want to be put on the stand and then someone put a picture of you or a video clip of you, like I said, mowing the lawn, throwing your kids in the air when you allegedly can't be walking. So be very, very careful with stuff like that.
That can really, I guess, in this environment, and there's a camera on you at all times anyway, especially right now on you doing this show. But I mean, there's always cameras on us.
There are.
And we never know who is filming us or who that person is sitting at the cafe near us when we're doing something.
Agreed. And even with what I do, when I get one of those in my hand, I'm thankful. It's a good day if I get something like that in my hands against the other side. So we do both plaintiff and defense work, so it goes both ways. And also, when you're in litigation, the other side is going to have the opportunity to ask you for documents. Give me every post you did on Twitter from the period of time of 2011 to 2012, and you're obligated to give documents like that. So it's all fair game.
Wow, had no idea. Yeah. So that's not private because you shared it, right?
Absolutely, it's not private.
Okay, I can imagine when people first call you, they're scared. They didn't sleep the night before. They were walking across the parking lot, or somebody knocked at their door or came to their workplace and served them with legal papers.
Yes.
Scared to death.
Yes.
Is your role to meet with them and to say, hand me that piece of paper and let me handle it?
Yeah, agreed. Yes, that's exactly what you do. In Florida, a person that gets served with a lawsuit and a summons has 20 days to answer the complaint. So that 20-day window starts as soon as you get that in your hands. And the date that complaint is served upon you, the court is notified of that date as well. So 20 days goes by, there's no response, you're going to get a default entered against you. Mm-hmm. And then you don't want someone to start collecting a judgment. So that's why there's a deadline. People think they can do things themselves, and maybe people are really savvy. I know I wouldn't have been able to do this on my own, prior to doing what I do. So don't wait. Don't wait.
And just from getting to know you briefly today and knowing Wade, for a number of years as I have, I just know that the comfort factor with your law firm is one that you just want to put your arm around the person, walk them out the door and say, now, go play with your kids instead of kicking the dog. I got this.
Agreed. Yeah.
Let me handle it.
That's what you hired me to do. You don't need to do anything once you hire me. If I need you for something, I will let you know. If you're going to be deposed, I'm going to prep you for it and make sure you know every question that's coming your way. So that's what you hire us for, the security too, that knowing that your case is in good hands. So sleep well. I mean, of course, litigation is probably very nerve-wracking and scary, but that's what you hire us for.
What about the temptation? Tim walks out of the radio station today. There's not only a man standing there with a blue folder, but there's also a TV camera from one of our stations here in town that loves that kamikaze nonsense. And just, hey, we got this guy on TV. He's being sued for this. What about that instant defense mechanism in many people. Man, I'm just going to talk to that camera and I'm going to tell him my side of it, or I'm going to call that guy that's suing me and give him a piece of my mind. Good advice, bad advice?
Bad advice. Just wait for your counsel, whoever you hire to talk to the other side. Anything can come back to bite you. You don't want to be admitting anything that isn't true because you're scared or because just of nerves. So just if you're being served, accept it. Accept the service of process of the summons and the complaint, and get someone on board to help you. And there's many occasions where I've been able to settle a lawsuit before an answer is even due. So you might not even be spending a lot of money on fees or anything like that, and avoid litigation already from the get go. So
have you ever had just a person come to your desk, and you read it on that free initial visit, and you go, "There's no basis for anything here."
Absolutely.
Go take a trip to the Bahamas. I got this because these people don't have a leg to stand on.
Many, many times.
Is that right?
Many times, yeah. And a lot of times it just takes a phone call to the other side to say, hey, you know what? Your case is kind of worthless. Why don't you rethink this and call me back? Because
I guess there are people out there. I mean, some of our situation comedies will get on that tangent where they'll do stories on that there are people who just sue people for just about anything, right?
Unfortunately, that's our society today, yes. There's a lot of frivolous lawsuits out there, but it doesn't mean you should ignore them because you think that they're silly.
But some people just settle because they think, well, there's no way I'm going to win this, so I'll give them the $50,000 or I'll give them the $10,000.
You try to negotiate something. I mean, sometimes, there's a lot of people that like to fight on principle. And sometimes principle's very, very expensive. Sometimes a good way to resolve things is to pay a little money to make it go away. But you got to deal with it.
Just say goodbye.
Exactly.
End of the day.
Exactly.
All right, chalk that up to experience. All right, we are at 12:51 on the show. Eileen is a great guest, and I'm sure that you have questions. If you would like to text us, you do so at 21232. If you want to call us, you don't have to use your real name. All right, 855-297-9696, the BCN Law Firm, bcnlaw.com, and you can give them a call this week. I love their telephone number. It is 855-LAW-2020. You can sing it. We'll be back. Hey, we're back. We only have 3 more minutes to spend together. Eileen, has it gone faster than you thought? Has it been simpler than you thought?
Everyone's really nice, which makes it very simple. So
is that host Rob Newton an idiot or what?
A little bit.
There you go.
But I'll deal with him. No, he's wonderful. He's wonderful, Rob. Great name, by the way.
My boss is listening.
By the way, Rob's a great name.
It's written on this cup here, so you can't miss it. Hey, Jack, do us a favor, Jack. Do not mention companies. Do not mention station names and or anything that might say who you're having a problem with. Go ahead.
Yes, just calling about contract law. Say you have a contract with a station or a radio station, and for some reason they don't like the way you're doing things, and they fire you, and you have a 3-year contract. What do?
How far are you into your contract, Jack?
It was like 60 days.
You were 60 days into your contract. Is there a temporary period that they can do that? Because most contracts have 90 days, a 90-day window. They can see if they like you or if they don't.
Right, but it's at will. As you know, the day and age of at will. Overseas in Afghanistan, there's contractors have at will, TV stations, radio stations. Now this clause, they can get rid of you at will. But what about this contract that you have?
Well, sometimes at will, sometimes even contracts for a duration of time, like a 3-year contract, do have at will provisions. So it really just depends on the circumstances of why whoever it is was terminated. Because sometimes they can, unfortunately. If it's not if it's at will, they kind of have the ability to do what they want if they're not happy. Obviously, they can't fire you for not agreeing to do something that's illegal or for discriminatory reasons. But sometimes at will, if they don't want, they can.
Well, and oftentimes in media contracts, and I don't know, Jack, in the case you're referring to, but in many media contracts that I've seen, that I've been privy to, it's also subject to ratings or subject to, some of the things that we in the business know control advertising costs. Any follow-up to that? He hung up. Okay, so you just never know, I guess. You would have to read the contract,
I would absolutely.
I'm sure.
I can't answer a question as to whether there's any rights on contracts without seeing it. So if he wants to call us at the office, I can take a look at that contract and see what it says.
And I guess just in non-contract employment in Florida, this is a right-to-work state, and this is they can fire you for anything, right? They can just say they didn't like the way you dressed that day.
Maybe a couple of warnings would be good. But if there's something they don't like and it's at will, they have the right to do that.
There you go. Well, Tim's okay. Hey, we're going to wrap it up, go to the newsroom to Dave Wall, who's worked here for 900 years and will never leave. We're going to ask the experts, continue up next right here on News 96.5.